Dear learners, I have already explained different classes of the years as structured under the scheme of Muslim law of inheritance. Now, how and in what order one class of the year will be entitled to inherit the property of the deceased. Now, this point I am going to discuss and is very important to understand with clarity. If really one is wishing to understand the gist of Muslim law of inheritance. The property of a deceased Hanafi, the deceased Muslim, Hanafi Muslim, goes in first instance to the years of class 1. I have already explained. Because class 1 are the first and best years, Quranic years, they are sharers. So, first of all, their claim will be satisfied out of the property left by the deceased. If property after satisfying the claims of the class 1 years, entire property is not consumed, something is still left, the remainder goes or will go to the years of class 2nd, that is agnatic class of the years will succeed to the property residue. After allotting the share to the class 1, whatever is that will be residue, and residue will go to the residuary class of the years, that is to the agnatic class of the years. Now, remember that in the absence of the years of class 1 and class 2nd, the property devolves on the uterine years, that is on class 3rd. Here it should also be clarified that if there are some members from class 1, that is from Quranic class, but there is no one from the agnatic class, then after satisfying the claim of the class 1, if anything is left, then that will directly go to the class 3rd. So, in the total absence of the class 2nd agnatic class, possibility for succeeding by the members of the class 3rd will be there. If anyone from the class 2nd is there, any member from the agnatic class is there, then there will be no possibility left for the class 3rd to succeed the property of the deceased. Now, I am coming to the allotment or allocation of the share to the years of class 1. By what rule of inheritance share of the Quranic class years will be determined and how it will be allotted. Detailed discussion I propose to make from here. Ladies and gentlemen, if you will again go back to the list of class 1 years, that is Quranic years, one will find that in the class 1 are spouses, that is husband and wife. Therefore, first of all, I will consider the entitlement of surviving spouse or spouse class from the Quranic class of the years in detail. So, let us first examine the right of each surviving spouse. I have already mentioned at the outset that on the basis of the importance, the years of a deceased Muslim are classified into two main classes, that is primary and secondary class. And in the primary class there are 6 relations, and one class of the relations included in the primary class of the years are spouses, that is the husband or widow as the case may be. So the spouses are not only class 1 but they are also primary. Spouses are the primary class 1 years. Primary means that they always will be entitled to succeed in the property of the deceased, and they will be entitled to inherit in order of the priority first. Therefore, first I am going to discuss the entitlement of spouses, that is of the husband and widow as the case may be. The Holy Quran specifically provides their entitlement in chapter 4, verse 11. Basically, the jurisprudential basis of the hereditary rights of the spouses is enshrined in the verse 11 of chapter 4 of the Holy Quran. One can go through this verse and assess, understand what is the share of the respective spouse of a deceased Muslim. Spouse survives, respective surviving spouse may be husband or may be widow of the deceased. It is their entitlement, hereditary entitlement is clearly mentioned in this verse, that is verse 11 of chapter 4 of the Holy Quran. For ready reference, understanding of the learners, I have mentioned this English translation of this verse, and learners can go through it for clear understanding of the regarding the entitlement of the surviving spouse or spouses as the case may be. Under the customary law of pre-Islamic Arabia, they were completely excluded from the inheritance. Under Muslim law, they are neither excluded now. Under Muslim law, they are neither excluded by anyone, by any year, nor can exclude any other year. The share assigned in the Quran to the spouses is either maximum or it is minimum. I have shown the chart, maximum, minimum. Maximum share for the husband, if the surviving spouse is husband, then the maximum share for the husband will be or is 1/2 or 1/4 of net total property. If the surviving spouse is the widow, then the maximum share for the widow as provided in the verse 11 of the Holy Quran is 1/4. Maximum is 1/4 and minimum is 1/8. So for husband, maximum is 1/2 of the net total property of the deceased. For the husband, minimum share prescribed in the Holy Quran, verse 11, is 1 by 4. Likewise, for the wife or widow, because after the death of the husband, wife will be called as widow. So, wife or widow will be entitled to the maximum under certain circumstances, and maximum share prescribed for the widow is 1 by 4, or minimum it may be 1 by 8. Now, everybody will have the quest to know when and why the surviving spouse is entitled to maximum or minimum. When the surviving spouse will take 1 by 2 or 1 by 8 or 1 by 4 or 1 by 8 as the case may be. This may be a very natural question sticking to the mind of the learners, and therefore I feel duty bound to clarify or to satisfy this quest. Surviving spouse, husband or widow as the case may be, is entitled to get the maximum share, that is maximum share when, again I repeat, the surviving spouses, H or widow, H or husband or widow as the case may be, is entitled to get maximum share when there is no rule 1 child, that is son or daughter of the deceased, and there is no agnatic male or female descendant of the deceased, that is there is no son's son, son's daughter, son's son or son's daughter as the case may be. Meaning thereby that a surviving spouse, husband or widow as the case may be, will be allotted maximum share 1 by 2, 1 by 4 or 1 by 4, 1 by 8, maximum share, the surviving spouse, husband or widow will be allotted the maximum share, that is 1 by 2 if it is husband, if it is widow 1 by 4, when the deceased has left behind no child, no his son or his daughter or both, and he has left behind no agnatic descendant male or female, that is a son's son or son's daughter, son's son or son's daughter, howsoever lower may be. In the total absence of these two categories of the relations, the surviving spouse, husband or widow will be entitled to the maximum. If it is the husband, he will take 1 by 2 of the net property. If it is the widow, she will take 1 by 4. So, the entitlements for the maximum share depends on the fulfillment of two conditions, that is, there is no one from the category of agnatic descendant, direct children, that is, there is no one from the category of children, there is no son, there is no daughter, or both are not there, and there is no one from the category of agnatic male or female descendant, that is, there is no one, there is no son's son, son of the son, or son or son's daughter, so on and so forth. If these two conditions are there, situation are there, then surviving spouse will take maximum. If it is husband, will take 1 by 2. If it is widow, she will take 1 by 4 of the net total property of the deceased. Here again I am using the expression net total property I would remind the learners, net property of the deceased here refers to the property left after the payment of three charges, that is funeral expenses, debts of the deceased and legacies. That will be net total property, and this out of this net total property, surviving spouse will be entitled to 1/2 or 1/4 if there is no one from the category of children. Here children means legitimate children, because under Muslim law illegitimate children are not entitled to inherit in the property of the putative father, but in the category in the property of the mother they are entitled. If it is widow of the deceased, she will be entitled to 1/4 provided there is no one from the children class, son or daughter, as well as from the category of the agnatic male or female descendant, that is the son's son, son's daughter, howsoever lower may be. Following examples will explain the rules more clearly. Means the example that I am going to refer will make the entitlement of surviving spouse more clear. Suppose the surviving spouse is widow, H dies. Suppose H is a person, propositus, and he has died leaving behind his widow, father and son's daughter. Here in this case, in one example, there are two examples. Example 1, you read widow, father and son's daughter. These are the three relatives who have been left behind by the deceased. Suppose deceased is H. So H has died leaving behind his widow, his father, his son's daughter. Now here I will discuss only the entitlement of the widow, whether here widow will be entitled to the maximum or will be entitled to the minimum share. Here in this example 1, the widow will be entitled only to the minimum share, that is 1/8 as prescribed in the Holy Quran. Reason because the deceased has left behind his agnatic female descendant, that is the son's daughter. Though one condition is satisfied, that there is no one from the children class, there is no son, there is no daughter, but there is one member from the agnatic descendant class, that is son's daughter. Because of the presence of the agnatic descendant member from the agnatic descendant class, the share of the widow will go to the minimum and she will be entitled to the minimum share, that is 1/8 in this situation. In example 2, you look at, there is suppose there is a death of the W, a woman. She has died leaving behind her husband H, her father F, her son's daughter again D. Here I will not discuss the entitlement of the father or son's daughter again. I will discuss only the entitlement as husband. Here husband, surviving spouse is the husband. Will he be entitled to the maximum quota of the share or minimum quota of the? Because for spouses, Holy Quran has fixed a quota of the share, and quota is maximum or minimum. For husband, maximum is 1/2, minimum is 1/4. For widow, maximum is 1/4 and minimum is 1/8. Here the surviving spouse in example 2 is husband. So whether in this case husband will be entitled to the maximum quota of the share or minimum quota of the share will be decided taking into consideration fundamental principle governing the entitlement of the surviving spouse. I have already mentioned the fundamental rules regulating or determining the entitlement of the surviving spouse. Fundamental rule or the golden rule prescribed by the Muslim law for assessing or for determining the entitlement of the surviving spouse is that surviving spouse, husband or widow, will be entitled to the maximum quota of the share, 1/2 or 1/4 if deceased has left no child. no son, no daughter, and no agnatic male or female descendant, no son's son, no son's daughter, howsoever high, lower may be. In this example, deceased W has left husband, father and son. There is a agnatic female descendant. From the category of the descendant, there is SD. The presence of the SD will reduce the entitlement of the husband, will make the husband entitled only to the minimum share, that is 1/4. So, as widow is entitled to the, because of the presence of the son's daughter, to 1/8 minimum, likewise the presence of son's daughter will make the husband entitled only to the minimum quota of the share, that is 1/4. And in this way, I think learner will be clear how the share, how the entitlement of the surviving spouse will be determined. Take into consideration the general principle of Muslim law relating to the inheritance or hereditary rights of the surviving spouse. Next example is suppose, in another example, suppose deceased W has died leaving behind her husband H, mother M, sister full, brother full. Now, in this case, what will be the entitlement of the husband? Husband, in fact, will be entitled to the maximum share, because there is no child of the deceased. Suppose here deceased is W, may say for example, W is a person. She has died leaving behind her husband, her mother, her sister full, her brother full. Now, here I will discuss only the entitlement of the husband of the deceased W. So, here surviving spouse will be entitled to the maximum quota of the share, that is 1/2, because it is the husband. Reason, because there is no child of the deceased W. There is no son or daughter of the deceased W. W has left behind no son or no daughter, and also has not left behind any son's son or son's daughter, means from the category of children as well as from the category of the descendants, no one is there. Therefore, surviving spouse will be entitled to the maximum quota of the share, that is, and here the surviving spouse is H, therefore, he will be entitled to 1/2. Now, take the another example, where the husband, suppose H dies leaving behind his widow, W, mother, son, sister full, brother full. Same example. There is only the difference that in one case there was a death of the owner was female, and in other case the propositus is male. H died leaving behind his widow W, his mother M, his sister full, his brother full. Here in this case also the widow will be entitled to the maximum quota of the share, which is 1/4 fixed by the Holy Quran itself. Reason, because there is a reason, there is a rule. Because of the rule she is entitled to 1/4, that is maximum. Reason, because there is no one from the category of the children of the deceased, as well as there is no one from the category of the agnatic male or female descendant of the deceased. Both the conditions are fulfilled. Therefore, here surviving spouse will be entitled to the maximum quota of the share. Since the surviving spouse is widow, therefore, she will take the 1/4. I have just told that I have not discussed the entitlement of other heirs of the deceased, maybe mother, maybe sister full, maybe brother full. Reason, because yet I have not discussed the rules determining share of the other heirs, maybe mother, maybe father, maybe brother, maybe sister, maybe sons, maybe son's son, so on and so forth. With this, I thank and hope that learners will be clear what I have discussed so far from the scheme of Muslim law of inheritance. Thank you very much.